The session is resumed. Senator Marcos, the principal sponsor, is once more recognized.
Yes, Mr.
And the Senator Sotto, on the period of interpretation, is likewise recognized.
Thank you, Mr. President. Mr. President, well, for the record, I beg the indulgence of the distinguished sponsor, but I wish to be educated, enlightened, and awakened by the sponsor on the basic law for the Bangsamoro Autonomous Region. So I have tried to put together my questions or my interpellation into 4 parts. Originally it was 6, down to 4. Let me start with part 1 today, Mr. President, and I hope to finish by 1 part a day, so that I can help in discussing the bill faster, Mr. President. So will the gentleman yield to this interpellation from this representation, Mr. President?
Certainly, Mr. President, to the gentleman from Quezon City, we will endeavor to throw as much light and to present as much information as possible, so as to make clear the different sections and provisions that he intends to take up. So with that, again, Mr. President, I yield to the gentleman from Quezon City.
Thank you. Mr. President, may we know the reason why this bill does not have definition of terms? Will the committee introduce the inclusion of definition of terms during the committee amendments, Mr. President?
We did that because I feel that there is no need. The terms as we have right now seem to be, in my view, self-explanatory. The only change in terms were around the word Bangsamoro, and let me explain what I mean by that. When we were as we were going through the Bangsamoro, the first draft of the Bangsamoro Basic Law, we found ourselves using the word Bangsamoro in many different ways. We were using it to describe the Bangsamoro people. We were using it to describe the Bangsamoro region. We were using it to describe the Bangsamoro government and sometimes even the parliament. And so, just in the interest of clarity, we decided amongst ourselves that the region will be called the Bangsamoro Autonomous Region. The area that is encompassed by the Bangsamoro Autonomous Region will be called that, the Bangsamoro Autonomous Region. Then there is the Bangsamoro government, the Bangsamoro Parliament, which I feel is clear enough. And when we use the word Bangsamoro by itself, the meaning that we ascribe to it is the people. So the Bangsamoro are the Bangsamoro people as defined in the substitute bill, now what we are referring to as the basic law of the Bangsamoro Autonomous Region, as the gentleman, I'm sure, is aware. In Article 2, Section 4, there is a very clear definition of the Bangsamoro people. And that now, now we use the word Bangsamoro to mean those that fall under the definition of Article 2, Section 4 of the substitute bill, which is lifted verbatim from the draft BBL.
I get the point of the gentleman, Mr. President, although I have a somehow deviated perspective. As a matter of fact, you were able to answer my second question somehow, no? Because
another new term is the non-moro. Just in the interest of completeness, Mr. President, the other new term that we have in the substitute bill is the non-Moro indigenous communities or non-Moro indigenous peoples. This now specifically is referring to what we normally call IPs. Pero hindi na maaring gamitin yung IP dahil kung titignan mo ang definition ng IP as we know it, the definition of IP as we know it would include even the Bangsamoro people. So to remove the confusion, we now have the two groups. There is the Bangsamoro people as defined in Section 4, and we now have the non-Moro indigenous peoples, which is the indigenous people of that area who are not Muslim, who are not Muslims.
All right. Well, before I go to, I said my second question that was somehow answered, but not entirely. There are several terms in the bill that are unfamiliar to me, to this representation, Mr. President, like block grants, Umrah, Haram, Hajj, etc. So I was thinking that these terms should be defined so that it will be clear to those of us who will not only support the measure, but those who will implement the measure, or people who are not familiar with the bar.
Yes, Mr. President. That point is well taken. It is, I suppose, what the rule that we followed is that if there is no definition found anywhere else, like if we look it up in the dictionary, or we Google it and Wikipedia it, or what, and it's available, like the terms that the gentleman mentioned, like the Hajj, is easily discovered what the Hajj is, the pilgrimage to Mecca, Haram, which are not disallowed items that are not allowed under the Quran. These kind of terms have a generally accepted meaning, and that generally accepted meaning is found in many reference materials. But having said that, Mr. President, if the gentleman feels that it is necessary for us to make a very precise definition of those terms and to include it in the bill, then I do not see any harm in that.
Yes.
Because it is in the similar vein that I keep reminding myself that what we are doing here is something different from anything we've done before. And it is not an extension of something that already exists. It is a new entity that did not exist before. And because of that, it serves to remind anyone reading the bill and anyone who will eventually implement the bill to understand precisely what those words and what those phrases do mean. And so, if we can include a definition of terms. In fact, I believe this is one of the bones of contention in the House of Representatives debate presently, as it stands. That there is no definition of terms. But although it is unnecessary in our view, I think that if it is found, if the gentleman feels that it is necessary, then I really do not have any strong objections to having those terms put in as part of the substitute bill.
Well, I'm glad to hear that, Mr. President. So at the proper time, we will propose amendments, and which hopefully will be accepted by the distinguished sponsor. So moving on to that question where I said my second question, which you partly answered, let me just place on record my thinking. Because Section 1 of your bill states that the bill shall be known and cited as the basic law for the Bangsamoro Autonomous Region. In other parts of the bill, however, the law referred to as the Bangsamoro Basic Law, or even simply Basic Law. I believe that if a short title of the bill should be used, it should be used throughout the bill. It should expressly state and use the same uniformly across the entire law. What do you think of that, Mr. Sponsor? Mr. President, I'm sorry.
Yes, but meron ba tayo natirang BBL dito? That's right. The gentleman is correct. We used the word, we used the phrase, we used the short title, Basic Law for the Bangsamoro Autonomous Region. I thought that we had expunged all reference to BBL, or the Bangsamoro Basic Law. What we do use as a shorter title, or to refer to the Basic Law on the Bangsamoro Autonomous Region, is Basic Law.
All right.
However, again, if it is not clear that we are referring, because if we pass whatever version we pass now in the Senate and by Congress, whatever version we pass, the Bangsamoro Basic Law simply will no longer exist because it has been amended and the titles have been changed. And the amended and the substitute bill, the amended bill, will now have the title, well, the original title, the full title, and the short title of Basic Law for Bangsamoro Autonomous Region. So we felt that it was sufficient to refer to that this is now the Basic Law. There is no Bangsamoro Basic Law in extant once we have passed this. And so that it will be clear that Basic Law refers to this substitute bill and the law that will eventually be passed.
All right. Thank you, Mr. President. We started reviewing the original bill that was presented to us. And then I transferred, or I moved on to reviewing your substitute bill, Mr. President. Now, I noticed that under Section 3 of the original bill, and now in your Section 2, you deleted the term or the phrase freedom of choice. May we know the reason for the deletion of freedom of choice under Section 3 of the original bill?
I am
Section 2 doon sa dating bill pala, Mr. President.
because we felt the Section 2 was not sufficient. In fact, if that is why we put in other provisions later on in the body of the bill that strengthens this idea of the freedom of choice of other indigenous peoples, and that has been established. That is why we had to. That is why we came to the new term that we have not used before, the non-Moro indigenous peoples, because we wanted to have a very clear reference and a very clear understanding to the groups that we are talking about, in Muslim Mindanao. So the Section 2 in the original bill was a little cursory, a little too short, a little too vague, and we felt that we needed to strengthen it, beef it up, as it were, and put in more details. The specific intent of all of the language in the bill that refers to indigenous peoples is essentially the to make an assurance to the indigenous people, the non-Moro indigenous peoples in Muslim Mindanao, in the eventual Bangsamoro Autonomous Region, that the IPRA law will be continuously and assiduously applied by the Bangsamoro government. And although the IPRA law already exists, it served. I think the events of the last couple of weeks have shown that there's a great deal more that needs to be done in terms of defending, respecting the rights and of our indigenous peoples, not only in Muslim Mindanao but all over the country. And so that is why we felt that one sentence was not sufficient. I think that so that we have made sure that the not only that the IPRA law is, as I said, assiduously followed, but also that there is a monitoring system for that to make sure that is the case within the Bangsamoro government, and that is the proposal that is contained elsewhere in the bill, where we have established the Ministry on Non-Moro Indigenous Peoples, essentially to protect and defend the rights of the non-Moro indigenous peoples in the Bangsamoro area.
All right. Thank you, Mr. President. As a matter of fact, I am glad that you removed it. It might be misinterpreted as a proposal of the International Planned Parenthood Federation, Mr. President.
Well,
just kidding. Levity aside,
Mr. President, I can see how that could be possible, and then that validates the decision to remove it. Therefore, to make the bill more clear and to make sure there is no room for misinterpretation.
Anyway, thank you, Mr. President. Let me
Furthermore, Mr. President, it also falls foul of on a constitutional basis, because the freedom of choice was a ground for striking down the MOA Act as unconstitutional. So if we return it into the substitute bill, we can guarantee that it will again be struck down by the Supreme Court.
Right.
So that was the basis. And since we were upon the subject anyway, we thought that we would, as I said, expand and strengthen the rules that govern the application of the IPRA law for the non-Moro indigenous peoples.
Okay. Speaking of the Constitution, Mr. President, Section 3 states that the purpose of this basic law is to establish the Bangsamoro Autonomous Region in accordance with the provisions of the 1987 Philippine Constitution and the etc. etc. Just a thought, Mr. President. If I'm not mistaken, you have mentioned and used this phrase a number of times in the bill, in accordance with the provisions of the 1987 Constitution. Ano ba ang purpose nito? Pandiin.
Dahil yan ang unang, kung maalala ninyo, nung unang nakita ang draft bill, wala pang isang araw, lahat ng ating mga commentator na abogado at constitutionalist ay sinabi unconstitutional ito, or it will require constitutional amendments. Kaya't para maliwanag, dahil meron tayong mga open-ended na sinasabi natin, binibigyan natin ng powers yung Bangsamoro government, at open-ended yung powers na yun, hindi natin linilimit. The only limit is it has to be whatever the Bangsamoro, whatever is passed by the Bangsamoro Parliament as a law will have to be in accordance with it has to be it has to be consistent with national law, and more importantly, it must also be consistent with all of the provisions of the Constitution. And the reason that it is repeated many times is to make sure, is to delineate very clearly exactly how far and what are the areas that the Bangsamoro Parliament can pass laws concerning subjects that the Bangsamoro Parliament can pass laws. But we have to be very, very consistent in saying that in these areas, in this or that area, that whatever is passed the Bangsamoro Parliament still has to be in accordance with, it has to be consistent with national law, has to be in accordance with the Constitution. Dahil kung hindi natin ilagay yun, maaaring magpasa sila ng batas na hindi na nga. Dahil nga yung powers na ibinibigay natin, bago ito eh. Hindi naman natin na ibigay, hindi naman na-devolve yan. This kind of autonomy has never been given to any other government, local government, or autonomous government. That's why many of these powers we are still in the process of defining it. So the Parliament, the Bangsamoro Parliament, trabaho nila yan. They will try and see and push the boundaries and see exactly what the limits are to those powers. And that the ultimate test will, of course, be the legal one, the constitutional one. So as long as they're legal, then it is allowed. And the legality of it will be determined, again, by its constancy with national law and it being in accordance with the Constitution.
Okay, thank you, Mr. President. Let me move on to Section 4. If this bill will be passed into law, Mr. President, may we know the expected population of the Bangsamoro people?
Good question. Meron ba tayong material dyan? What is art? Well, actually the question is, I cannot answer the question about the Bangsamoro Autonomous Region definitively, Mr. President, dahil ang mga kasama sa Bangsamoro Autonomous Region hindi pa na-determine. Dahil hindi pa tayo nagpe-plebisito, hindi pa natin alam kung ilang probinsya ang masasama sa Bangsamoro Autonomous Region. And that is the only way, hanggat wala pa tayo ng listahan ng mga probinsya at mga lungsod na sumama sa Bangsamoro Autonomous Region, hindi natin mabibigay ang numero ng nakatira doon sa area ngayon. As a guide, however, Mr. President, ang population na nasa loob ng ARM is approximately 4 million. So, if the core provinces, the 5 core provinces, member provinces, stay within of ARM, stay within the Bangsamoro Autonomous Region, then more or less we will have the same,
at least
more or less.
At least.
Kung may dumagdag, then that will be additional. But as a guide, I think as a starting point, as a baseline, we can use the population of ARM, which is, to be very exact, 3,943,000, according to the. I would imagine this comes from the NSO in their census that they conduct.
So you
I
would
believe
not,
this is the last one. It was 2010.
you will not venture, I guess. The reason I asked expected, what is the expected number?
Hindi natin masasabi
Hindi
because
masabi.
we really
All right.
cannot say what
Okay.
the results of the plebiscite will be.
Let me tell you why I asked that, Mr. President. In your Section 4, you define Bangsamoro people as those who at the time of conquest and colonization of the Philippines by the Spaniards considered themselves natives or original inhabitants of Mindanao, whether of mixed or full blood, provided that the foregoing profess the faith of Islam, shall have the right to identify themselves as Bangsamoro. Spouses and their descendants, at their option, shall also be part of Bangsamoro Autonomous Region. Anyway, my query there, Mr. President, is that does this mean that even Bangsamoro people residing outside the geographical area of Bangsamoro Autonomous Region shall be covered by the Bangsamoro Basic Law? Then, if this is the definition that you have.
No, that merely defines the identity of the Bangsamoro people. whether or not they are inhabitants of the Bangsamoro Autonomous Region. The law, the organic law, will necessarily only apply to the autonomous region and to those living in the autonomous region. So
only those living in the autonomous region.
If you are living, for example, in Metro Manila, the organic law, the basic law, does not apply to any of the bodies of government in Metro Manila. So the laws that will be the basic law will not apply to any area outside the Bangsamoro Autonomous Region.
What do you think is the reason, Mr. President, that this timetable was chosen by the proponents of the Bangsamoro, basically those who at the time of conquest and colonization of the Philippines by the Spaniards considered themselves? Why this particular time in our history? Why not during the time of Limahong? Or maybe beyond that? Why do you think they chose this?
I believe this was because this was the beginning of the conflict. Because until the Spanish time, there was no group that came in and tried to forcibly convert people of any other religion, into Catholicism, which is what the Spanish tried to do successfully in other parts of the country, but obviously unsuccessfully in Muslim Mindanao. And so the Bangsamoro people are those who oppose the imposition by the Spanish occupiers that all inhabitants should be members of the Roman Catholic faith. That is again, that is, I believe, that is the beginnings, at least, of the Muslim Mindanaoans beginning to fight and to start a conflict with what is, I suppose, would have to be referred to as the then central administration of the Spanish, centered here in Metro Manila, but of course all over the country. And to make very, very clear that from the very start, that this has been the reason why they have had movements to separate that area, because it is because of that specific difference. So I believe that is a snapshot in the history of the Philippines, where this conflict really started to gain ground and started to become something of a national issue for the Philippines, even before we were even a republic.
All right. Thank you very much, Mr. President. But will you please help me understand the next section, Section 5 of your proposed bill? It states that the rights of the non-Moro indigenous cultural communities shall in no way be impaired, diluted, or diminished, even when such non-Moro indigenous cultural communities are situated within the confines of the Bangsamoro Autonomous Region. Does this mean that even if non-Moros are inside the Bangsamoro Autonomous Region, their properties and persons are not covered with this law?
No, quite the contrary. We are saying that the law has to be consistent, specifically with IPRA and other laws that protect the ancestral lands, the rights and the promotion of the culture of the non-Moro indigenous peoples. And that is why although it is again unnecessary, because the IPRA law is out there, it's already a law, and it is to be followed and implemented and followed. It was to make very, very clear what was the basis of what should be the basis of the treatment of the non-Moro indigenous peoples within the Bangsamoro Autonomous Region. So the laws that the Bangsamoro Parliament, the basic law, will apply to non-Moro indigenous peoples.
All right.
The any laws that are passed by the Bangsamoro Parliament will also be applicable to all inhabitants of the Bangsamoro Autonomous Region, whether or not they are the Bangsamoro people, whether they are settlers, whether they are indigenous peoples.
Thank you for that, Mr. President. I am enlightened. Now, may I move on to Section 7? Section 7, prerogatives enjoyed by traditional Islamic institutions such as the Sultanate. Do we have an exclusive list of the traditional Islamic institutions as contemplated in Section 7 of Article 2? Are there any guidelines or requirements before an institution can be considered as a traditional Islamic institution?
We do not have a master list, as it were, of sultanates or even the royal families, not only the sultanates, but the other royal families. We do not have any such definitive list that categorically includes all of the sultanates. This process is something that needs to be determined within. For example, in some sultanates, there are recognized, there is a sultan that is recognized. There are also other pretenders who, by virtue of their bloodline, claim to be the sultans. And that is that determination must be made by the sultanates and the members of that sultanate themselves. And it is not, I believe, for us, precisely, it is their traditional way of governance. It is their traditional way of administration. And it is precisely, this is the kind of autonomy that we are giving them, that they make that that decision as to who they believe to be the true leader of their group is. Who do they believe belong to the real royal family? Who, in fact, should occupy the positions of leadership within the sultanate? So we do not determine that. We allow the traditional groups, essentially the royal families, to determine for themselves who are the leaders of that royal family, of that group, for that matter, of that tribe. That is one of the areas that we left to the sultanates, because we do not actually have any system for determining that. And the only way to determine that is really within the royal houses and the sultanates, as they choose, whichever method they choose to determine that leadership. That is something that we leave to them, Mr. President.
Mr. President, there are 2 points in Section 7 that I want to understand. Traditional Islamic institutions. I wish there was a definition on what is a traditional Islamic institution. Perhaps I can be enlightened on what it is. No? And then the next one is, if you read the provision section, the prerogatives enjoyed by traditional Islamic institutions such as the sultanates shall be maintained. What are these prerogatives?
The prerogatives, the prerogatives that they enjoy are, for example, to arbitrate when there are conflicts within the royal group. Within their group. I think we can see this in many tribal cultures, wherein when there are conflicts between certain parties, for example, something simple, land, the usual, water, or the ownership of livestock, for example. When there is a conflict, they bring this conflict to their leader, and their leader, after trying to glean as much information from them, will make a determination that in their judgment who is in the right. That is a prerogative that they enjoy furthermore, they also in the different rituals that are being that the sultanates and the royal houses go through, they play a part in that because of their authority. To answer your first question, second, I think the simple definition of the most general way that we can describe traditional Islamic institutions as it is referred to in Section 7 is to talk about the royal houses. And if as I'm sure many of us have experienced, you go to Mindanao, you will be introduced to a datu, you will be introduced to a sultan, you will be introduced to a prince and a princess, because they belong to the royal house. If we have attended a Muslim wedding in the south, you will also see that they explain very clearly the bloodline of those that are being married, the parents of the newlyweds, again to explain precisely what their place is within that royal house. So I think I think it is a fair description of what we are talking about when we talk about traditional Islamic institutions in Section 7, to say that it refers to the royal houses. Now, what if they are sultanates, if they are come in another form that is different, the versions are found, but again, they are all recognized as royal houses. And the families within the royal houses are recognized as members of that royal house.
Okay, we'll take note of that, Mr. President, and we'll review the possibility of including it if necessary. But then, in my second question on the prerogatives that are being enjoyed by these institutions, you mentioned conflicts. What else? When you say prerogatives in the plural sense, there are others.
Yes, the same. Another, as I said, in the rituals, the roles that they play, the fact that they can use their titles, that they can call themselves a prince or a princess or a sultan or a datu, that we continue to allow them to do, and whatever else that they do within the traditional grouping that they lead, that we will be continuing. I suppose in each one that there are slight differences, but essentially they provide leadership, they provide vision, they also provide guidance, and as I mentioned earlier, arbitration. They will also be, if we look further into that section, that the representatives of such institutions shall be consulted by the legislature. And the process of consultation of these leaders of the royal houses is certainly a traditional prerogative. So there are quite a few of these prerogatives that actually have been are tried and tested over many centuries and have been shown to be effective in keeping problems at bay, keeping the cultural heritage, on promoting the cultural heritage, and continuing in the traditional way in the modern world. And that is essentially the balance that we are trying to strike here. Of course, they exist in the 21st century, but whatever prerogatives or privileges or powers that they might have exercised as traditionally, then I think that should be allowed to continue, because that is the very essence of the identity of those peoples. And that is precisely the reason that we are writing a basic law. This is precisely the reason why we are forming an autonomous government, because it is to respect, to recognize those differences, to recognize the differences in culture, to recognize the differences in history, in law, of course in religion, and to allow the inhabitants of that area to, as much leeway as possible, to continue that within, again, the law of the land and the constitution of the country.
Well, as I said earlier, well, first of all, thank you for that, for the explanation. As I said earlier, I need enlightenment as well as continuing education on the purposes of this section, Mr. President. Now, my next question is on Section 8. It's quite lengthy, Mr. President, so I beg your indulgence. Let me start off with saying that in the old version of the bill, it made mention of terrestrial, fluvial, and alluvial domains and the aerial domain above it as part of the territory of the Bangsamoro Autonomous Region. However, in our revised version, the aforesaid phrase has been deleted. Does it mean now that these or those areas mentioned will not be a part of a geographical area of the Bangsamoro Autonomous Region, which will have no jurisdiction over it? Now, in your revised version, geographical area refers to the land mass as the waters over which the Bangsamoro Autonomous Region has jurisdiction. So are inland waters included? Because in the old version, there was a particular section on inland waters, but now deleted also in the revised version, which may give an interpretation that inland waters are not part of the Bangsamoro Autonomous Region.
No, quite the contrary. In fact, there is language that later on in the bill that says that specifically says that all the land within the Bangsamoro Autonomous Region, all the waters within the Bangsamoro Autonomous Region are under the jurisdiction of those spheres. We have removed any such reference that might be misconstrued and misinterpreted. I do not believe that that was the intention, but for the rest of the country, to allay those fears that this is a step to separatism. So it is not the territory. We call it the Bangsamoro area. To get back to the specific step to separatism, so to assuage, as I said, those fears, we have removed any such reference that might be misconstrued and misinterpreted. I do not believe that that was the intention, but for the rest of the country, to allay those fears that this is a step to separatism. So it is not the territory. We call it the Bangsamoro area. To get back to the specific question, Mr. President, what this is actually we tried to adopt because it simplifies also all of these the territory of the landmass as well, the maritime, terrestrial, fluvial, alluvial domain, and the aerial domain above it. There was discussion as to the aerial domain, because that would again seem to intrude upon the powers of the national government, of the state. And so to remove any doubt, we removed that part of it. And it is essentially a simplification, because when you talk about landmass as well as waters, then you already have the maritime, terrestrial, fluvial, and alluvial domains. It is only the aerial domain that has a connotation, once again, of a power that essentially belongs to the state.
So what you did was a catch-all provision, mentioning waters. May I know what provision is that you cited, Mr. President?
I'm talking about Section 8. Again, it is just a simplification. Oh, I'm sorry. I am looking also at the original BBL, and I am looking at Article 3, Section 1, entitled Definition of Territory.
Ito yun. Land mass as well as the waters over which the Bangsamoro Autonomous Region has jurisdiction. Is that all?
Yes, that is now that is the existing Section 8.
All right. The new Section 8. Okay. Now, in the case of accretion, just for my enlightenment, in the case of accretion, who shall have jurisdiction? Bangsamoro or Bangsamoro Autonomous Region or the national government?
What in what sense accretion will we you mean, are you talking about a possible
Deposit of land, Mr. President.
you
Alam
mean
nyo naman, nagbabago ang ano
I understand, like a delta and okay. No, this still remains under, because what is defined is the
Area.
boundaries.
Oh.
of
So within,
the
so within.
Bangsamoro. So anything within.
Bangsamoro yun.
Yes. So if there is a change in the landscape somehow, and if that adds land area, that will still be under the jurisdiction of the Bangsamoro government.
Okay, thank you. Now, Section 9, Mr. President. Section 9, letter C, states that the geographical area of the Bangsamoro Autonomous Region shall also include any province or city which are contiguous and outside the geographical area of the present arm. Now, it only mentioned province or city. May we know if municipalities are included, Mr. President?
No, they are not. The only when the plebiscite is conducted, the only local government units that can opt, should they vote in that way, can opt to be included in the Bangsamoro Autonomous Region are cities and municipalities. And the reason is that we fall into a very difficult situation. Number one, where the definition of and the changes that are being made to an area, for example, a province. Let us say just a municipality will decide to leave that province, and it is to join the Bangsamoro Autonomous Region. That then there are other requirements in the Constitution, in the Local Government Code, and in many other laws about how that is to be done. And so we cannot do it unless it is a province or a city. Kasi kung hindi na natin, pagka city o province, hindi na natin hahatiin, iibahin ang bayan na nasa loob ng probinsya, ang mga barabarangay sa loob ng isang lungsod. Kaya ginawa na lang namin, and this is also to be consistent with the arm organic law in that city, and during the plebiscite for the inclusion into the arm, the judgment was made that it should only be cities and provinces, seeing as their transfer from one entity, one province, or their transfer from whatever administrative area they belong to will not be too difficult. Dahil nga buo na sila. There is a whole province, it's a whole city. So that to transfer. Pero kung maglilipat tayo ng bayan, ng municipality, then that is a different story altogether, because you have to then redraw the boundaries of that province. The situation becomes even more complicated and difficult if you include barangays. That will immediately bring, and that's why the question of contiguity is something that we made very, very clear, that it all must be contiguous. Otherwise, it is impossible for us to be able to administer them if they are non-contiguous to the Bangsamoro Autonomous Region.
So you are saying it is mandatory. Contiguous must be mandatory.
Oh yes, it is.
All right.
It is here that the
All right.
language says,
Which are
which
contiguous.
are any province or city
Yes.
which are contiguous and
outside.
outside of ARM, the present ARM.
Thank you,
So
Mr.
kung
President.
pipiliin nila na ninanais nilang masama sa plebisito, actually this 10%, a petition of 10% of the registered voters in the area asking for the inclusion is not the inclusion. So it is sometimes misinterpreted to mean that by 10% petition that they are already immediately included, and that is not the case. What it means is that they will be included in the conduct of the plebiscite as that will define what is the Bangsamoro Autonomous Region.
Right. Can you explain to us the step-by-step process for the inclusion of any province or city in the Bangsamoro Autonomous Region, Mr. President?
Very simple. Dahil ito minsanan lang. This only happens once. This happens before, can happen only 2 months prior to the actual conduct of a plebiscite. For example, a province decides that they would like to be part of the Bangsamoro Autonomous Region. That decision has to be manifested, or that desire must be manifested by the petition of 10% of the registered voters of the city or the province. Once that petition is made, then they are automatically included when the plebiscite is conducted. Should the plebiscite, should the results of the plebiscite show that that city or province has voted in favor of inclusion into the Bangsamoro Autonomous Region, then they will be included into the Bangsamoro Autonomous Region. There's a way to... I just thought of everybody include themselves and then...
Well, I was about to ask if a mere resolution pass a law government unit suffice, or that you make mention of 10% of the registered voters in the area asking for inclusion, yung pala to be included in the plebiscite.
Sa plebiscito lang. Marami nga nagrereklamo, sinasabi na that's not democratic.
Hindi. Tsaka it is, it will not comply with the provision of the Constitution, which requires that only provinces, cities, and geographic areas voting favorably shall be included in the autonomous region. Ibig sabihin na, so, tama na ngayon ang intindi ko sa inyo, 10% to be included in the plebiscite.
In the plebiscite, oo.
Paano kaya nating malilinaw yan dyan? Hindi malino. Tenyo, ang basa ko sa Article 3, Section 9.
Well, ang nakalagay dito is asking for the inclusion at least to... Asking for the inclusion, we can probably still strengthen the language here.
Dagdag na natin, like letter D, Section 9, states that a petition may be filed by at least 10% of the registered voters in the area asking for their inclusion, period. Hindi ba? So, their inclusion in the plebiscite. Pwede natin sigurong ilagay yun.
Iba yung binabasa. What the paragraph C states is that
D.
Wala akong D. I am looking at the substitute bill. The language is slightly different. The original B bill included what was the so-called opt-in provision. The opt-in provision was that at any time, the province or city, with the petition of 10% of the registered voters or a resolution of the local sanggunian, could ask that a plebiscite be conducted that they be included into the Bangsamoro Autonomous Region. Yun yung tinatawag na opt-in provision. Without a corresponding opt-out provision. So, kung nasa loob ka na ng Bangsamoro Region, hindi ka na makalabas. Pero kung nasa labas ka, maaari ka pa rin masama at pumasok sa Autonomous Region. That was a very difficult that is a very difficult provision to actually impose for very many reasons. And that is why we simplified it and made the opt-in provision. There is essentially, technically speaking, an opt-in provision, but it happens only once, and it happens only before the plebiscite is conducted. So in the language in paragraph C, there is any project contiguous when there is a resolution of the local government unit or a petition of at least 10% of the registered voters in the area asking for the inclusion. Maybe we can clarify this. This must be done 2 months prior to the conduct of the plebiscite.
At saka yung 10% registered voters, Mr. President, just for your reaction, can't we include a minimum number of years that they have been registered voters? Kung biglang hindi ba? Maniobra itong isang grupo. Gusto nila, makakasama kami. Biglang nagpa-register ng kung sino-sino ron. Yung pala, kare-register lang. At hindi naman talaga sila mga dating registered voters doon. Madali po yung 10%.
Tignan natin, but magtanong tayo. I think we have to see if it is actually a practical thing. Kung kaya ng, halimbawa, ng COMELEC na gumawa ng ganong klaseng determination, titignan nila kung ilan ang, let us say, namili tayo, 5 years or 10 years, whatever the number it is we decide upon, if they can actually make the determination of who are the registered voters who have been in that area. But again, what yung mahirap siguro din dyan will be to decide how long will we require them to have been registered voters.
Well, perhaps dapat nakaboto nung nakaraang eleksyon.
At least one election previous.
One election previous.
Well, let me make inquiries with the COMELEC to see if they have that kind of information, if they can generate the kind of information that would be required if we are going to put in that kind of requirement.
That's fine with me. Thank you very much, Mr. President. Now, after the approval of the Bangsamoro Basic Law, can there be additional inclusion of provinces or cities in the Bangsamoro Autonomous Region? Section 9 only contemplates on the inclusion before the passage of the Bangsamoro Basic Law.
No, there is no. There is nothing that resembles the original opt-in provision.
So wala na yun?
Wala na yun.
All
Hindi
right.
na natin sinama yun because I think that with the consultation with the other members and with the other groups, they said that this was simply impractical. Again, there are many requirements to change what is included especially in an autonomous region. Then how we will have to remove them. For example, if it is a province, they will have to be removed from the region that they belong to because they will now move to the autonomous region. That will require reorganization of that region. That has many complications involved, and it is not as simple a matter as just getting the vote in the plebiscite and moving a province from one region to another. The regions are organized as administrative entities, and to move from one to another would be very complicated, and I do not know if I believe, in my view, it would probably be, in fact, counterproductive.
I concur, Mr. President, because I've even heard a comment saying that if there is an opt-in, there should be an opt-out.
Yes, that was much.
That makes it more complicated.
That actually makes. But that's why we cannot allow it, because it would only seem to be fair to, if you have an opt-in, to have an opt-out provision. But to do that, then you are continuously changing. There is a prospect that you will be continuously changing the boundaries of the Bangsamoro Autonomous Region. You will be continuously changing the boundaries of the regions that surround the Bangsamoro Autonomous Region. And kung masama pa, because in the original opt-in, the contiguity was a gray area, wherein contiguity did not seem to be a requirement. So masyado na talagang magulo. So it is not a practical. It would not be a practical arrangement. It would be impossible to administer.
All right. Thank you, Mr. President. I move on now to Section 10. May we know the reason why the term central government was changed to national government in the substitute bill? Does it have any implication on the powers of the Bangsamoro regional government?
No. What it does is how it has implications on the recognition of the national government as not merely being a central government, but being the overarching political entity. That is because central government, for example, you can talk of a highly federalized state. There is a central government, but the powers of the states are very are quite substantial, and the central government only serves as a kind of a coordinating and monitoring entity. Then that is not what we are going for. We wanted to make it very, very clear that this is an autonomous government, but it is still under it is still a political entity under the national government. So the word central was not, I believe, clear enough. And I think national government covers, answers all of those fears that it will not be, that this is a political territory that will not be part of the national government. This way we can make it very clear that they are very much part, they are an integral part of the national government.
Thank you, Mr. President. Again, I approve of that reason. Now, your last paragraph of Section 10 provides that, quote, 10 years after the passage of this basic law, the national government and the Bangsamoro regional government shall discuss the improvement of the Bangsamoro Autonomous Region waters through necessary processes and modalities. May we know from the sponsor, Mr. President, what does this paragraph seek to achieve and what are these supposed processes and modalities?
They essentially, that paragraph essentially refers to development of all the waters, both the coastal and inland, in the Bangsamoro region. And if the Bangsamoro government has any proposals for example, increased development in a certain area, the inclusion of national programs or the, shall we say, the reinforcement of national programs in certain areas, that is one of the areas that is one of the reasons that we have this paragraph. The other one is to do with the conservation of the environment. Throughout our hearings, all of the groups, including the MILF, including the IPs, including all, were all very concerned with the environment and the ecology in the Bangsamoro region. And I believe that just shows that they are ancient cultures that have a very clear understanding of the importance of preservation of the environment and for the ecology to be not only preserved but to be further developed. So between the development of businesses, programs that they will have to do in coordination with the national government, there will also be assistance needed from the national government for the preservation of the environment in the area. It is something that clearly came through in our hearings, that it is an important aspect of governance for in the Bangsamoro region for all its inhabitants, and that is why we made sure that there is a possibility that that when there's assistance needed for whatever reason, for the development, for the preservation of these inland waters, that this can be done in coordination with the national government.
Why 10 years, Mr. President? Just for the record.
Well, because by 10 years we will have a good idea about what has happened, the trends that have already will already be slowly recognized. For example, the movements of populations, because we necessarily, when the Bangsamoro Autonomous Region is established, I believe there will be some movement in the populations. There will be perhaps some other developments in terms of programs that the Bangsamoro now that the Bangsamoro government does not need now or does not feel is necessary for the moment, but will find to be necessary further on. And I think 10 years is sufficient time for the Bangsamoro government to see what it is that will be necessary for the continued development of these waters and also for the continued preservation of the ecology.
Okay. Moving on to Section 13, Mr. President. May we know the reason for choosing parliamentary form of government for the Bangsamoro?
Very simple. We tried to stay as close to the original proposal as we could, and the original BBL proposes a parliamentary system of government, And again, upon examination, the legal opinion on whether or not a parliamentary system of autonomous government within the unitary Republican presidential system that we have in the rest of the country is unconstitutional. And so I felt that it was sufficient, a case can be made that it is in fact constitutional. And since that is the request of our Muslim brothers and sisters, then I do not see any problem. So long as it is proven to be constitutional, I do not see any problem that they should have the form of government that they choose.
All right. Then that means I move on to Section 14, where you say that the electoral system, the Bangsamoro regional government shall adopt an electoral system suitable to a parliamentary form of government which shall allow democratic participation, encourage formation of genuinely principled political parties, and ensure accountability. Paano mo yun? How is that?
That has to do, Mr. President,
Anong role, may role ba ang COMELEC dito? Yung shall
malaki.
adopt an electoral system?
Dahil ang gagawin pa, pagka napasa na itong batas, we will still have to determine what are the parliamentary districts. Dahil meron na tayong members of parliament. And each
yung
member...
current ng ARM.
Kagaya ng ARM, meron tayong assemblyman. This will be slightly different dahil it is a parliamentary, so member of Bangsamoro Parliament sila. And what is the definition of the districts is still to be determined. That is one of the areas that we left again to the transition authority to decide how to organize the parliamentary districts. And we just wanted to be sure that in the organization of the parliamentary districts, that they are truly representative. Halimbawa, wag naman yung isang distrito na ang population 2,000, yung isang distrito 100,000. That is not a proportional representation. So just that kind of situation, so as to be clear that as much as possible, we be as even-handed in terms of giving representation. We have the same kind of idea where we say that every entity that has a certain number of voters in it is already qualified to have a congressional district. So we're saying that we should also have a look and make sure that each one of those districts encompass an area which requires and deserves representation in Parliament. We have seen the redistricting in many LGUs. Quezon City is one of the examples that we recently did. And so that process, this is just describing that process, wherein we can change the district, we can move the districts, we can redefine the districts so as to make it as representative as possible.
It is the Bangsamoro regional government that shall do this? Or the national government? Parang hindi ako nalilinawan dito. The way I understand it is, the Bangsamoro regional government shall adopt an electoral system suitable to a parliamentary form of government, which etc. 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 Anong role ng COMELEC dito? Anong role ng national government dito? Sila na ito.
Well, ang ginawa namin ay sinundan lang namin ang congressional districts. Also to align with the number of members of parliament that will be elected. So with that, we determined that out of 60, 40 will be elected. Therefore, we have to define 40 districts, parliamentary districts within the Bangsamoro Autonomous Region. This actually it's a good question because kung magbago, halimbawa sa plebisito, napakaraming sumama na probinsya, lumaki ng husto yung Bangsamoro Autonomous Region, baka hindi na sapat yung 40. Baka kailangan natin dagdagan. So I think that a mechanism still has to be evolved so that we can be more more responsive to the actual situation on the ground. This
Whi-
applies.
I'm sorry, I'm sorry to butt in. Which brings me to my original question: is the Bangsamoro regional government the one who will do that?
Right now, we can. Right now, we just follow because right now we have no option to do that. All we have done is we have followed the original proposal of the membership of the Bangsamoro Parliament. We have assumed that it will be applicable to a region that will be similar, if not exactly the same as ARM. That is the only guideline that we can have right now. So if we choose to change the definition of the parliamentary districts, I believe that the Bangsamoro Parliament should have that power in the future. But for the very beginning, we just followed the congressional districts as they are now.
Well, based on that kind of a perspective, what is the role of the COMELEC, Mr. President?
The role of the COMELEC is the same as its role in any other place. They will conduct.
With the under the supervision of the COMELEC.
We
Something
actually
to
have
effect.
that language further on in the bill, where it specifically refers to the COMELEC's duties. The Bangsamoro COMELEC office's duties in the Bangsamoro. They are exactly the same as the COMELEC office's duties in any other LGU, province, city, municipality.
All right. So yeah,
that's
under direct supervision of the
under
COMELEC.
direct supervision
National,
and control of the COMELEC.
All right. Thank you. Now, Section 15, Mr. President. With the passage of the Bangsamoro Basic Law, which expressly, and I quote, renounces war as an instrument of national policy, adopts the generally accepted principles of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity of all nations. End of quote. Now, will this ensure that there will be no further violence in the Bangsamoro Autonomous Region? Will this prevent breakaway insurgent groups? What do you think, Mr. President?
I'm afraid there are no guarantees in that regard. As you can see, there are still elements outside of Bangsamoro in the Philippines that are continuing to wage violence against the government, with an eye to bringing down the government and to bring about violent change. So, despite it not being a national policy, we must, all we can do is to make sure that we are aware of any such intentions by any group and counter them. That is the best that we can do. We cannot control small groups from sprouting up and deciding that they should take up arms against the government. But however, it is not allowed, or it is a the stated policy of the Bangsamoro government itself. Well, and another individual group we can only monitor and try to control them, whereas the Bangsamoro government cannot indulge in a change in policy that embraces violence as a matter of as an instrument of change. As another side note, I would just like to make very clear that in that paragraph, it was pointed out earlier by Senator Pimentel that the word national should actually read regional. Because at this point, we are saying that this is a policy determined by Bangsamoro government for national. That was an oversight on my part, and we left in national.
So you mean renounces war as an instrument of regional
policy? Exactly. So doon sa area nila, na hindi sila, basta sa area nila, hindi nila papalitan ng kanilang policy at sasabihin ay kami lumalaban na sa pamahalaan.
So, well, at the proper time, it probably will be a committee amendment.
That is right.
So, okay.
That is right.
Thank you. Thank you, Mr. President. Section 16, Mr. President, states that the Bangsamoro regional government shall enact measures that protect and enhance the right of all people to human dignity, reduce social, economic, and political inequalities, and remove cultural inequities. Does the phrase right of all people include Moro or non-Moro people and even foreigners, Mr. President?
Well, I think this is just an abbreviated restatement of the Bill of Rights, Mr. President. It is just a recognition that the Bill of Rights is still the guiding that still has all the is the guiding principle that we follow whenever we are dealing with the rights of individuals. So this will include everyone.
Yes.
That is within the Bangsamoro, or for that matter, even non-inhabitants, but those that are within the jurisdiction of the Bangsamoro government.
So the answer is in the affirmative, Mr. President.
That is right, Mr.
All
President.
right, thank you. Section 18, Mr. President, recognizes the rights of the non-Moro indigenous peoples. May we know how how are the non-Moros affected by the passage of this bill?
Well, that is because, as has been pointed out, there will be conflicts and alternate claims on land is usually what the problem is. And the rights that we are talking about are those rights that are ascribed to them by, again, the IPRA on ancestral domain for the indigenous peoples. So once those have been determined, because it is possible that it will be misinterpreted by some, saying that, oh, meron na tayong Bangsamoro Autonomous Region, amin lahat yan. Amin naman talaga yan eh. Parang ganon. May mga ganon, meron ako naririnig na ganyan. Kuminsan palabiro, kuminsan hindi. And that is why this had to be made very clear that no, if they are the ancestral domain of the indigenous, non-Moro indigenous peoples, then that ancestral domain is recognized, will be recognized by the Bangsamoro government. It usually has to do with, again, with land, with water, the supply of the supply of water. This kind of really quite common conflicts that we see not only in Muslim Mindanao but around the country.
All right, thank you for that, Mr. President. Section 19. It relates, Article 5, no? Section 19 relates to the reserved power of the government. I think I comprehend most of it. But however, number 11 of Section 19, which pertains to free ports, basically gives the Bangsamoro regional government the authority to establish and operate the free ports within the areas. Isn't this supposed to be included in Section 20 under concurrent powers? And can we be clarified?
The gentleman, Mr. President, is exactly right. We only saw it. Mali nalagay namin sa maling section. That does not belong there. That belongs, as precisely as you have pointed, as has been pointed out, to concurrent rights, because there will be joint administration when it comes to the creation of the free ports within Bangsamoro is within the powers of the Bangsamoro Autonomous Region. However, the collection of tariffs, the collection of fees, etc., will still have to be conducted by the customs, and so it is a concurrent right. And yes, it does not belong there. It does belong in the section on concurrent powers.
All right, thank you. Now, so we will expect that from the committee. You know,
that will be a
need
committee.
Not be an individual amendment.
That will be a committee amendment when the time comes.
Thank you. Also, are there any limitations or guidelines for the creation of establishments of free ports? I'm afraid this may be the subject of abuse. As provided in the bill, in your bill, free ports enjoy the same benefits as a special economic zone, both tax and other incentives. Now, there should therefore be a limit, or at the very least, guidelines as to how this may be created by the Bangsamoro Autonomous Government, since any special economic zones will invariably affect the national government. Baka mangyari dyan, Pagka merong genius na nakapasok dyan, gawin lahat report yun.
Oo nga, na lumabas din yung posibilidad na yan nung sa aming usapan. But again, I think that it would now run counter to the idea, to the language that says that the Bangsamoro regional government shall coordinate with and assist. Ibig sabihin, kailangan masasabi ng national government, hindi nyo pwedeng gawing Freeport lahat dahil hindi natin pwedeng i-administer yan. At ang mangyayari dyan, ay siyempre, alam na natin ang mangyayari, it will be used as a legal smuggling point. But so long as the national government is still involved, and they'll say, sige, kung meron pinopropose na Freeport, na halimbawa, sabihin natin 30, sasabihin ng national government, hindi feasible yan. Dahil unang-una, hindi tayo makakolekta at magiging problema para sa CIQ natin, para sa Customs, Immigration and Quarantine. So, hindi namin kayang i-administer yan at sa palagay namin it's a bad idea. That is why it is required that they will coordinate with and assist the national government on Customs, Immigration, Quarantine services and international commitments. That's important, because the country has international commitments concerning things like free economic zones and free ports. So again, it has still to be coordinated with the national government. It has still to be consistent with the national policy of government on free ports and eco zones.
Your explanation is clear, but I don't see it here. So
I thought that coordinate and assist would be sufficient. But kung gusto nating patibayin pa, ay wala naman siguro.
Mas maganda pong malinaw.
Wala naman sigurong problema doon. So,
baka nga may mga genius na lumitaw eh.
Palagay ko nga meron mag-iisip na magandang idea yun, na buksan na lang lahat. Pero hindi talaga maaari at magiging, siyempre, magiging notorious lang yung area na yan na kung ano-anong pwedeng ipasok at hindi makakatulong yan sa Bangsamoro region.
Thank you, Mr. President. I'm glad that the gentleman agrees.
Pwedeng gawin dyan.
All right. Section 20, Mr. President. May we know the reason for establishing an auditing unit in the Bangsamoro Autonomous Region? What would be the effect of the establishment of a separate auditing unit to the functions of the COA? What kind of relationship will this separate Bangsamoro auditing unit have with the COA? And will the auditing unit be under the control and the supervision of the COA, or are they considered separate or distinct, Mr. President?
Mr. President, this is precisely one of the main points that were found to be unconstitutional in the original BBL. In the original BBL, there would be an Bangsamoro Auditing Office, a BAO, was the original proposal. However, it was not clear that its relationship, that Bangsamoro Auditing Office, what the relationship would be with the COA. Now, the Constitution clearly states that the COA will audit all of the government entities according to well-established, well-recognized, and accepted auditing practices, and that is the mandate that the COA has. We just wanted to make it very, very clear that we are not in any way diminishing the powers of COA as mandated by the Constitution by having a separate auditing office in the Bangsamoro. Now, although there is some language that says they will still be reporting to the COA in the original BBL, it was not clear under whose control and supervision it was. And because of that, then there was a question as to that provision's constitutionality. So we tried to, in this language here, make it very, very clear that the Bangsamoro Auditing Office will be under the supervision and control of the COA. It will be the equivalent, I guess, of instead of provincial auditing office, an auditing office, the COA, let's say COA Quezon City or COA Manila or COA Tagbilaran, it is going to be just the COA in the Bangsamoro. So they will still fall under the auspices of their hierarchy, of their organizational structure under COA. Furthermore, Mr. President, this was something that needed attention, because we hear over and over again that ARM was a failed experiment. And I have to say once again that I do not agree. But nevertheless, that is a reason given why we are reorganizing the autonomous region. Now, one of the main problems that we saw in the ARM was the misuse of funds. And I think what happened in the Maguindanao, in the massacre in what is now referred to as the Ampatuan, the Ampatuan massacre, is that we saw upon further examination that much of the funds were not used to provide services or to develop the ARM. There were several instances where it was clearly shown that the funds that the national government was giving to the to the ARM government were being used to buy arms, were being used to buy expensive automobiles and vehicles, were used to build very luxurious houses, and just went into the pockets of some of the officials there. And so, if we are to remedy that situation, and we saw what the effects of that kind of entitlement that the leadership began to feel, we have to make sure of the transparency and accountability. If this is to be a success, especially since much of the funding that will go into the Bangsamoro autonomous region will come from the rest of the country, then the transparency and accountability must also be very clearly seen by everyone around the country. So it cannot be an internal audit. It cannot be an audit that merely reports to the COA. It must be a very clear process of auditing within the general accepted practices that we already apply to other local government units and the national government, for that matter.
All right. Thank you. I take that, Mr. President. Although, if with a review, I hope you will not mind if we can tweak this a little, just in case.
Mr. President, any improvements to the substitute bill are most welcome.
All right. Thank you very much. Let me move on to number 6 of Section 20, Civil Service. With the creation of the Bangsamoro Autonomous Regional Civil Service Office, or the BAR CSO, how will this affect the current setup of the Civil Service Commission? I wish to be clarified on the specific power or duty of the national government as regards to civil service, because the provision, the way I read it, is I'm not quite clear as to the national government's participation relative to civil service, except that the organizational structure and staffing pattern are to be designed and implemented by the Bangsamoro Regional Government. It says shall be subject to the minimum standards and guidelines prescribed by the Civil Service Commission. May we be enlightened, Mr. President?
Yes, this is another case of a very obvious constitutional question in the original BBL, wherein the civil service was separate or could be interpreted as being separate from the Civil Service Commission, wherein we know that the Civil Service Commission is a constitutional body and its jurisdiction must apply to every part of the country. So, again, this will be similar in concept to the Commission on Audit Office of the Bangsamoro. It will be the CSC office in the Bangsamoro region. Now, the reason that the Bangsamoro regional government shall design and implement its own organizational structure is that they are parliamentary system, and therefore they will necessarily be different from the other structures and systems that we use around the country. and it is up to them to design that. But however, the guarantees that the Civil Service Code provides for its members, for the members of the bureaucracy, must still continue to apply. The guarantees on tenure, the guarantees on pay grade, the guarantees on seniority, the guarantees on benefits, all of these must continue. And that is why there is mention here of that it is all subject to the minimum standards and guidelines prescribed by the Civil Service Commission. In other words, the treatment of all members of the civil service, all civil servants, be they in Bangsamoro Autonomous Region or outside of it, the treatment should be the same. We will continue to follow. The Civil Service Code is a law, is a national law, and that is the guiding. That is what guides the standards and guidelines of the CSC, and those should also pertain when it comes to the Bangsamoro Autonomous Region.
That includes salary standardization, security of tenure, unions, collective bargaining.
All of the privileges, all of what is allowed, what is granted in the Civil Service Code should apply to the bureaucracy in the Bangsamoro Autonomous Government.
All right. Thank you, Mr. President. You practically answered the next two questions that I had for section for number 6. I mean, of section 20. Now, still on that, concurrent. Well, may we know the reason why the Coast Guard matters is under section 20, under concurrent powers, and not included in the reserved powers of the national government, considering that the national defense is included in section 19 under reserved powers?
The Coast Guard is not seen as part of the national defense, Mr. President. It is
because it is civilian in character.
It is a civilian entity, and it's not part of the armed forces of the Philippines. That I think the nature of the Coast Guard is beginning to change. They are becoming closer and closer in nature to the AFP. But however, as it stands now, they still are a civilian organization. And although the national, it is again similar to other LGUs. In other LGUs, we have the Maritime PNP that is still under the national government, but of course they work in coordination with the local government. So the concept here is exactly similar, exactly the same as that, in that there needs to be the job of the Coast Guard cannot be done by taking orders only from the headquarters in Manila. The situation on the ground must always be taken into account, and that is why this is a concurrent. That is why this is a shared power between the national government and the Bangsamoro government.
Mr. President, I'm very sorry. I'll have to beg your indulgence. I'm stuck with Section 20. I was hoping that my first part, which can end up all the way up to Section 27, can be done today. But apparently I lack time because I really have to terminate my interpellation at this point. Not terminate, but suspend. So if you don't mind, Mr. President and the distinguished sponsor, let me suspend my interpellation on Section 20 and proceed on Monday, Mr. President. I'll try to finish Part 1 all the way on Monday, and hopefully my Part 2 included also on Monday, Mr. President.
Thank you very much, Senator Sotto.
So I wish to thank the sponsor, Mr. President, for answering my questions.
It was certainly the gentleman is most welcome.